Good afternoon. My name is Sheila Lamb, and I'm with the Virginia SBDC Network. For those of you who are not familiar with our organization, the Virginia Small Business Development Center is a partnership program between the U.S. Small Business Administration, George Mason University, and local host institutions throughout Virginia. With 26 locations across the Commonwealth, we provide training and technical assistance to small businesses in their local communities. Our one-on-one advising services are available at no charge. Today's webinar, Trademark Basics, is presented by the Virginia SBDC Network in collaboration with the U.S. Patent and Trademark Office. We are recording today's presentation, and it will be posted on our website, virginiasbdc.org. Due to the large number of participants, everyone's microphone is muted and the chat feature is turned off. But if you have questions during the presentation, you can type those into the Q&A box, and we will adjust them at the end of the session. We have also enabled the live transcript function, which you can show or hide via your own meeting controls. And now it is my pleasure to introduce our presenter for today's session, Marisa Terrell. Marisa began her trademark law career at the USPTO in 2000. After her departure from the USPTO, Marisa worked as a solo trademark practitioner, in-house trademark attorney consultant for Lockheed Martin and Leidos Corporations, and trademark and fashion law professor at her alma mater, Howard University School of Law, HUSL. In 2015, Marisa was recruited to manage the USPTO Trademark Law Clinic at HUSL and was instrumental in helping to develop a patent clinic at HUSL in 2019. Marisa returned to the USPTO in 2020 and currently works as a trademark attorney advisor in the Office of Trademarks Customer Outreach, where she delivers to experienced practitioners educational content on advanced trademark topics. She earned her JD from Howard University School of Law, her BA magna cum laude from Pace University in New York City, and is admitted to the Maryland and District of Columbia Bar Associations. In her spare time, Marisa volunteers with the High Tea Society, a life skills program for DC girls. Please join me in welcoming Marisa Terrell.
Thank you so much, Sheila. It's my pleasure to be here today. We have a lot to talk about, so I want to jump all the way in. I don't have really any announcements except to say that I'm going to do my best to answer your questions at the end of the presentation. But please remember that even though I'm an attorney, I'm not your attorney. I represent the U.S. government, so I can't necessarily answer fact-specific questions, but I'm going to do my best to show you where you can go to find answers. Also, I'm understanding that you are going to receive a copy of the slides. If you haven't received them already, I think Sheila's going to provide them to you. So don't worry. I know that's a lot of information. So let's go ahead and get into it. We're going to talk today about trademarks, what they are, and why they're so important to protecting your business. We will discuss why the federal registration can be beneficial, how you can select a strong trademark, what are the steps for filing a trademark application with the U.S. government, and what do you need to do to maintain that? And lastly, we're going to talk about where and how you can find help. Today's discussion really is a legal training for you. Hopefully, the information that we share is going to help you on your federal trademark journey. Trademarks and intellectual property. So what in the world is a trademark? Trademarks are a type of intellectual property. The property itself is not tangible, but it still can be bought and sold, inherited, traded, and protected. Fun fact about trademarks, they are all source identifiers. What does this mean? It means that the primary purpose of a trademark is to indicate the source of goods and services. Let me see if I can say that a different way. You do not have a trademark unless it's used in commerce to identify specific types of goods and services. Let's run through a few examples so that I can sort of explain that concept further. When you look at the screen, you don't see much right now, but I'm about to run through some different trademarks, and hopefully you can help me better understand the goods and services that are offered under each one. So when you see this bitten apple, what goods and services are sold under this symbol? If you're thinking mobile devices, computer software, maybe even the services of retail store services offering those products, technical support system, all of that's accurate. This mark is owned by Apple Incorporated to identify all of those different things. You see this Coca-Cola scripted wording in the stylization, just like this. What type of goods and services come to mind? Perhaps the beverages of the Coca-Cola branded soft drink. Maybe soft drinks is what you're thinking of. That's a product sold underneath this Coca-Cola brand or this Coca-Cola trademark. What about this stylized M? Doesn't represent me, right? This is representing a company that sells a specific type of hamburger, a specific type of French fries. It also offers, restaurant services or maybe even medical services for children. Okay, the Ronald McDonald House, that symbol is used for that too. And Amazon for online marketplaces, Samsung Electronics, Microsoft for software, like word processing software, Google for search engine services, this stylized check mark owned by Nike for athletic shoes and apparel and stores selling those same things, and Ford, specific types of cars and trucks. All of these are trademarks. All of them are used to identify specific goods and services offered in the marketplace. So let's go back over what a trademark does. A trademark indicates source. It's a way for customers to distinguish goods and services from others. And it also provides legal protection for a brand. Think about it like this. You actually stand upon trademark laws, those regulations, in order to have a bevy of support for when you want to go after somebody else for maybe misappropriating your brand. These are the rules that you would use, you would lean into. These would be those trademark rules and regulations. When you think about distinguishing goods and services, just think about going into a restaurant and you're trying to figure out, looking at the menu, what type of soft drink to order. You might call out a specific brand using the trademark, right? Because you want to make sure you let your waitress know you prefer Coke over Pepsi, helping to distinguish with her the type of soft drink that you want. Now that we know what a trademark is, let's make sure we understand what a trademark is not. A trademark does not mean that you own a specific word and phrase. Now, you might say, whoa, I thought it absolutely meant that. No, it means that you have the right to use a word or phrase to identify your specific goods and services in the marketplace, but it doesn't mean you legally own it against all others, okay? When you have a trademark, it doesn't mean that you can stop anyone from just saying your trademark out loud, right? Okay. And it also doesn't mean that people are going to owe you money if they say a word or phrase. Remember, trademark registration means you have the right to use a specific word or design, etc., in connection with a specific good or service. A few slides back, we saw some examples of different types of marks. Well, trademarks can take several forms, including brand names, slogans, designs, logos, combinations of such, okay? These are what we call traditional marks. Let's look at some examples again. Coca-Cola, traditional mark. This is what we call a standard character mark. It's all written in just plain text, and it means that you're asking for protection for the wording with no specific stylization at all. When you submit a trademark application and you request protection for a standard character mark like this, that means that you have the right to use your mark in any font and any color. So that's kind of cool. Standard character marks. The standard character marks can be in capital letters, lowercase letters, or camel case, uppercase and lowercase together. Here's another traditional type of mark. It's a slogan. It's the real thing. Just like the word in Coca-Cola, it's the real thing is owned by the Coca-Cola company, and it's used to identify a specific type of product, a specific type of beverage. And here again, another type of traditional mark. This is a logo. We also might call this a stylized mark or a composite mark. It consists of wording and a design together, smushed together to create a static image. This particular logo is in black and white, which is also something fascinating to note. If you seek protection for a black and white image, if it's registered, you will have trademark rights, federal trademark rights to use that specific image in any color, any size, okay? That's another sort of perk and sort of fun fact from participating in this slide presentation today. And finally, here's an illustration. This illustration likewise is used by the Coca-Cola company to identify a specific type of beverage. This illustration with no wording at all is likewise a traditional type of mark. What about non-traditional types of marks? These are super fun. Not all trademarks fall into the traditional mark category. Non-traditional marks are some of these: sound, color, scent, motion, hologram, configuration. Let's give a few examples to help you sort of think through how these could possibly be federal trademarks if they're registered with us. Imagine that if an owner consistently uses a sound in relationship to specific goods and services, and those products are offered for in commerce, okay? Now you have trademark rights. So what is that sound? Here's one. What about the sound that the lightsaber makes? Think about the lightsaber from Star Wars. If I had one in my hand, it would sound like this. Zew, zew. Okay, great. That sound, in and of itself, not a trademark. But when it's used to identify Halloween costumes and toys, well, all of a sudden, you can have some trademark protection if the mark is used in commerce. In that case, Lucasfilms does own the trademark for the sound that that lightsaber makes when it's used to identify lightsaber toys and Halloween costumes. What about the color? The color of maybe pink. You see this box down at the bottom left on the screen. That is supposed to represent fiberglass, the kind of fiberglass that's in the walls of maybe a residential home. That fiberglass sometimes is pink. When you see pink, that color associated with fiberglass that is sold, that where that color is used in commerce to identify fiberglass, all of a sudden you might have some trademark rights. And indeed you do, because Owens Corning owns the color pink for use in identifying fiberglass for residential homes. That is a non-traditional trademark. Other color marks might be brown for package delivery services. UPS owns that color in relationship to those services, and you see them on trucks all throughout cities across America. What about scent? If you think about it, there is a specific scent that Hasbro uses to indicate that a specific molding clay comes from Hasbro. And what is that scent? It's a scent of Play-Doh branded molding clay. Okay, it's like a sweet, yeasty, vanilla kind of scented molding clay. When you smell that, hopefully you're going to think of Hasbro toys. Okay, and maybe motion marks. If you think about the Pixar movies, whenever they start in the movie theater, you're going to see a white screen. The wording Pixar, you'll see a lamp pop up and jump on top of that letter I, and it'll sort of has a little head of the lamp and it'll flash into the screen, okay? That entire little short motion, that little film, little clip is called a motion mark. And it is used to let an audience know that the next animated movie you see on that screen is coming from Pixar, okay? Holograms, like maybe the hologram on the American Express card to let customers know this is a legitimate American Express card representing credit card services, okay? Or what about the shape of the Coca-Cola bottle itself? I'm talking about that three-dimensional bottle, sort of that hourglass. They were the first to use that shape for their bottle and get it registered with us. And so that configuration or shape, even without any wording, is going to let a customer know that what's in this bottle is going to be a specific type of beverage, one that is coming from Coca-Cola. Okay, so as you're thinking about what type of trademark to use and to register with the U.S. Patent and Trademark Office, think outside the box and perhaps think of some non-traditional types of marks. Let's do a knowledge check. Let's make sure you're still hanging in here with me. Does a federally registered trademark mean that you own a specific word or phrase? What do you think? You can definitely drop your information into the chat window if you like. But the answer would be no. Just because you have a federal registration doesn't mean that you're going to own a specific word or phrase. Remember, you have this the exclusive right to use that word or phrase to indicate the source of your goods and services. Do you have to use your business name as your trademark? What do you think? Do you have to use your business name as your trademark? No, many companies decide not to use their company name as their trademark. Um, Sometimes they do, but remember, a company name is the name that you register with your state so that you can conduct business in the state. And there are times when folks use that name, and there are other times when they want to actually create a trademark. Sometimes you can register your trademark through your state and you would get state rights. Other times you might decide to register it with us and to get federal protection. All right, let's keep moving forward. Why in the world would you register your trademark with the USPTO? What are the benefits? In the United States, there are lots of different ways to create and secure your trademark rights. Common law is one way, federal registration is another way, and I just mentioned even a third way, state trademark registration. We're going to talk about these two, common law and federal registration. Let's talk about common law now. Common law rights are created as soon as you begin to use your trademark in commerce. Whoa, that's big. Let me see if I can say that again. Once you begin to use your mark to identify your goods and services, you are protected under common law trademark law. Okay, this is the common law that guides these types of trademarks. All right, you don't have to do anything else. You don't have to register with us at all. But remember, when you're operating under common law, there's a couple of caveats. Number one, when you're operating under common law, your protection is limited to the geographic location where your mark is used. You do not have national coverage, okay? Another thing that you want to bear in mind is that when you're operating under common law, there are specific symbols that you can and cannot use. For example, if you're operating under common law, you can use the TM or the SM superscript. Now, TM is typically used to indicate that you have a trademark that is used to identify goods, and the SM or service mark is typically used when you want to let folks know that you have a trademark, right? And that trademark is used to identify services. But these days, most folks just use TM. We don't necessarily use SM all the time. It's up to you, your choice. One thing you won't do, though, is use the R in the circle. When you use that R in the circle, you're letting folks know that you've registered your mark with the USPTO. And so if you have not gone through that application process and you have not obtained a registration certificate, you cannot use that R in the circle symbol. So what about those federal registration rights? When are they created? Federal trademark rights are created when your trademark registers with us, the USPTO. So let's review a few takeaways about federal registration. Once you have a federal trademark registration, there is a presumption that you are the owner of the trademark, that you have the right to use your trademark in all 50 states and territories. Okay? And this federal registration gives the public notice that you are the owner of the mark. Now, what do I mean by that? This idea of notice, like due process, like notice, you want to make sure that folks know that you have the rights to use that mark, and you want to put folks on notice of that fact. It gives constructive notice, and I'm going to tell you how this notice comes about. Basically, when you apply, you submit your application with us, and it's reviewed by an examining attorney. There's a part of the process that would indicate that your mark, once it's like reviewed and there's no like issues with it, it's going to go to a place called the Official Gazette. And it's going to sit on the Official Gazette for anyone in the world who's paying attention to be able to see that and to see how you're using your mark, what goods and services you're using it with, and they have an opportunity to object. This is that notice I'm talking about. If there are no objections, then your mark, if everything's all right with it, is going to move on to registration. Okay? So it is that period of being published in the Official Gazette That is why you can say, yes, I've given folks notice, of course, that I am operating under having a federal registered mark. That is your goal. And when you have that notification, you can let folks know that. Okay, let's keep moving forward. As soon as you register, you're going to receive some terrific benefits. What are some of those terrific benefits? Well, you can bring a legal action in federal court. Okay, that's great. You can all of a sudden record your federally registered trademark with U.S. Customs and Border Protection. That's awesome because the benefit of the U.S. Customs and Border Protection Office is that they will seize counterfeit items coming into the country that bear your trademark that don't originate with you. And so that's a great tool, a great way to enforce your federal trademark rights by registering your trademark with the Customs and Border Protection. Notice that the USPTO is not going to be the agency to enforce your rights in that manner. The U.S. Customs and Border Protection is going to be where you go for assistance. And finally, you can use your U.S. trademark registration to extend trademark protection in other countries. There's no such thing as an international trademark. Instead, you typically, if you wanted to use your trademark in other countries, you would have to register your trademark in each one. But if you use your trademark application or your trademark registration, you can actually use them as a launch point to obtain protection in other countries like Canada, Mexico, China, right? These are countries that are part of the Madrid Protocol. And with this treaty, you can use your application and your registration to obtain protection there. There'll be some additional money. And of course, there will be some additional paperwork, but you can start that process with our agency, the USPTO. That's a good thing. What symbols can you use once your trademark registers? Okay, you're no longer going to use that TMSM. Instead, you're going to use that R in the circle, registration symbol. All right, here's another knowledge check for you. Make sure you're still hanging in here with me. Are you required to register your trademark with the USPTO? What do you think? Is that a requirement? No. Federal registration is a choice. Many trademark owners apply for federal registration because they want nationwide protection, and that's sort of one of the great benefits of using our federal application and registration process. Does registering your trademark with the USPTO give you international protection? This is a trick question. I'll say it again. Does registering your trademark with the USPTO give you international protection? The answer is no. Registering your trademark with the USPTO only provides rights in the United States and its territories, okay? That international protection requires some additional steps from you. It requires you to take that trademark application that you filed with us and use it as a launch point, or take that trademark registration you obtained from us and using that as a launch point, relying on the Madrid Protocol Treaty. And you can find that information on our website. Simply type in Madrid Protocol and you'll be able to it'll take you straight to some newly updated web pages that will provide you with that additional information. Okay, let's keep going. Selecting a trademark. Now you know what a trademark is and you know what it is not. Let's talk about how you can select one that will hopefully sail all the way through our application process on to registration. So, a couple of points. The USPTO is tasked with registering any trademark eligible for registration. We want to register every single mark, believe me. But sometimes rules and regulations will prevent us from doing so. One other thing I want you to note is that not every trademark is registrable. We're going to discuss two common reasons why a mark may not be registrable, or why an application for a mark is going to be refused by our office, okay? And so that's what I mean when I say not every trademark is registrable. Sometimes there's some legitimate reasons why we cannot move your mark to registration, and those reasons are based on statutes and case law. And the other point I want to make is that not every trademark is enforceable. Now, this is really important to note. We talked a minute ago about common law protection. I just want you to bear in mind that in the United States is the first to use a mark in commerce, that's going to be the one that's going to have superior rights. So it's the first to use a mark in commerce to identify specific goods and services. They're going to have superior rights. So if there's someone who has been using their mark in commerce and never registered their mark with us, they may be able to enforce their rights over yours if you registered your mark later than they started using their mark. Okay, that's something for you to bear in mind. You want to make sure that you select a mark that's going to be registrable. That means that there won't be any reasons based on statutes or case law to prevent your mark from registering with us. But you also want to pick a mark that's going to be enforceable against anyone who might not have registered their mark with us. So you want to make sure you were the first to use your mark in commerce to identify your specific goods and services. Select a trademark that's both federally registrable and federally protectable. The most common refusal is the likelihood of confusion refusal, and we're going to talk about that further. Here, what we want to think about as we're moving into the next section is that there are two common reasons why your trademark might be refused: likelihood of confusion and strength of the trademark, maybe a merely descriptive refusal. Okay, and we're going to talk about those two main concepts next. Here we go. Selecting a trademark. Likelihood of confusion. As I mentioned, one of the most common reasons to refuse to register a trademark with our office comes from Section 2D of the Trademark Act. Under this statute, a trademark can be refused registration where a likelihood of confusion exists. So how do you know if there's a likelihood of confusion between your mark and another mark? Well, you're going to apply the likelihood of confusion test. If you were to read the case that talked about the test, you will find that there are a lot of different factors for this test. But we're going to whittle down those factors into two simple questions that you're going to ask yourself. And we're thinking about this test in this manner. The whole purpose of trademarks is to avoid confusing consumers about the source of goods and services. And so that's why we want to make sure that when folks apply to register a mark, that there is no likelihood of confusion between their mark and another mark that's already registered with us. Okay, so let's get into that test. I wanted to make sure I gave you the sort of the background before we jumped in. The test is two-part. And the first part seems pretty simple. You're going to ask yourself, if you're thinking about whether your mark is confusingly similar to another one, you're going to first say, are the marks similar? Well, that's the legal framework. This similarity, how do you determine that if the marks are similar? You're going to ask yourself, do they look alike or sound alike or have the same meaning? And once you go through that, if you have a yes there, you'll move on to the next prong of the test. Are the goods and or services offered under both marks related in any way? That's the test. Let's move on and give some great examples. Here we go. In this particular example, let's say that your trademark is T.Markey, okay, and is being used to identify shirts. Great. Let's say that you conduct a search of our database before you file because you're trying to figure out if you're going to get a refusal based on likelihood of confusion, okay? Your search results reveal this mark, T.Markey, used for pants, and you're thinking, all right, is there a refusal in my future? And what's the test you're going to apply? I'm asking myself, are these marks similar? Do they look alike or sound alike or have the same meaning? In this instance, the marks are identical, so the answer is yes. Now I'm looking at the goods offered under both marks, and I'm saying to myself, are these goods related? Are shirts related to pants? Now, how would I know? Well, I might do some research, but because I know clothes, okay, I might not have to do much research. In fact, I can think of 10, 20, 30 different companies that own a trademark that's used to identify shirts and pants together. Because of the number of owners I can think of that own a trademark for shirts and pants together, I can provide some evidence that these goods are related. So these marks look the same. They sound the same. And the goods are related because customers are used to seeing one company make both pants and shirts under the same marks. Okay. So refusal here. All right. Let's do another one together. What about these two? Again, your mark is T.Marky for shirts. And the competitor's mark that you find when you conduct your own search is T.Marky for pants. All right. Is there a refusal coming based on that likelihood of confusion, Section 2D of the Trademark Act? Let's see. Are the marks similar in sound or appearance or meaning? Well, yeah, the marks sound the same. So that's enough. That cute spelling of with that Q is not enough to distinguish those two. There still is a similarity between the marks. And now I'm going to look at the goods. And again, we said in the previous example that shirts are related to pants. So yes, there's a refusal here. The marks sound the same and the goods are related because customers are used to seeing one company make both pants and shirts. Let's do another one. What if your mark is T.Marky for shirts again, but you find in your search of our database T.Marky for golf flags? What do you think about this one? Is there a refusal here? I don't know. Let's think about it together. We're looking at the marks and we say, yes, we know that they are similar in sound. So there is a yes, they are similar, the marks. But what about these goods? Are they related? Here, customers might not be used to seeing one company make shirts and golf flags. I don't know off the top of my head. So I'd probably have to do some research on my favorite search engine, Google, um, Firefox, somebody, right? I'd have to go into some type of search engine to see, maybe DuckDuckGo or something, and I would do a search to try to figure out if I can find a number of different companies that are selling golf flags and shirts under the same trademark. If I can find a large number of them, then that might be enough evidence to show that these goods are related. Okay? It requires research to determine the answer. That's part of a good clearance search. Okay, so how do you determine whether your mark is confusingly similar to another mark, or how do you determine whether your mark is going to be refused registration based on a likelihood of confusion under Section 2D of the Trademark Act? How do you determine that? You're going to do your own search, okay? Or maybe you might hire an expert to conduct a search for you. If you're doing your own search, where are you going to look? You will start, hopefully, on the USPTO database. It's free. And our database consists of all federally applied for and registered trademark. Our search system is new. It's been updated recently. We hope that it's much easier to use. It's available 24/7. But one thing it doesn't do is it doesn't provide information on common law marks. Remember, those are those marks that haven't been applied for or registered through our system. Okay? The other place you're going to search is the internet. That's one great place to find those common law marks, those marks that have not been applied for or registered with our system, but are still in use. So you want to make sure you do both of these things before you file, because we do not generally issue refunds, and we would hate for you to select a mark that is going to, off the top, be refused registration because it's confusingly similar to another registered mark. Okay. Another option, if you don't want to conduct the search yourself, is you might want to hire an expert. An expert would be a private trademark attorney. Now, notice I didn't say an expert was one of these filing companies, these non-attorney filing companies. They might not be the best option because they're not attorneys and they might not understand how to determine whether their search results are going to be high risk or low risk because they might not be familiar with the laws of the land. Okay. So but that private trademark attorney, where are they going to search? Would consist of a comprehensive clearance search. A comprehensive clearance search, the type of search that a trademark attorney would do, is going to consist of a search of our database of registrations and applications, state trademark databases, okay, business name registries, foreign trademark databases, and of course, the internet. A terrific private trademark attorney is not only going to give you a printout of the search results, they are going to go through each one with you and help you determine which search results are high risk of obtaining a refusal, right? Which ones are going to be considered confusingly similar, etc. That's what they'll do. And sometimes they'll even write up a memorandum to explain why some marks are more problematic than others. That's the benefit of hiring an expert. And of course, don't forget the internet. Definitely, a comprehensive search includes searching the internet. All right, here's a knowledge check that I want to just throw in here. We're sort of at the midway point of the presentation, but I want to do one more. What if your mark is X-seed and you're offering agricultural seeds under that trademark, okay? And then what if you conduct your search and you find X seed, okay, for live plants? You're going to do the analysis because you want to know, is there a high risk that I am going to receive a refusal based on 2D, Section 2D of the Trademark Act? That would be that likelihood of confusion refusal. Looking at the marks together, I'm going to ask, okay, are they similar in sound, appearance, or meaning? They sound the same, so check. Then I'm looking at the goods and I'm asking, are they related in any way? Check. I can think of a lot of different owners that are selling live plants and agricultural seeds under the same trademark. And so, yes, I would say that they're related here. So, yeah, probably there's going to be most likely a refusal. The marks sound the same and the goods are related because customers are used to seeing one company provide plants and seeds under the same trademark. Okay. Great. So we got through one hurdle of the likelihood of confusion test. And so now we sort of understand why the likelihood of confusion refusal is applied and what sort of are the factors that you want to use to analyze your mark and your search results. Okay. Now let's talk about another common refusal. This refusal centers around the strength of a trademark. The concept is that you want to avoid using trademarks that don't indicate source for goods and services. Because remember, that's the whole point of a trademark, source identifiers. The second most common refusal that you will receive with our office is a merely descriptive refusal. Okay? The test is, does the mark merely describe the goods and services offered under the mark? And when you talk about merely describing, I mean, does your mark or the mark in question describe the quality, a feature, a user of those goods and services? Does it describe the purpose of the goods and services, ingredients, etc.? Because you want to avoid using those trademarks that cannot indicate the source of the goods and services. Okay? You want to actually select a mark that's distinctive. That's where we're headed. And why do we say that? Because distinctive marks are marks that will typically be considered strong. These are marks that, because they are considered strong, distinctive, they will be easier to protect. That's what we say. All right. But let's see if I can give you some examples so that you can sort of make this decision for yourself. I want you to have the rules in place so that you can apply them to your specific scenario. So in this instance, how do you determine if your mark is not descriptive? Okay, we can use this temperature gauge. Some folks like to see visual infographics like this to help. Great. In this instance, if you're staying in the red zone, okay, you're headed towards the strongest types of marks, distinctive types of marks, marks that are afforded the most protection. You want to stay out of the blue zone, okay, if you can help it. Here we go. What is a generic term? Remember, it's generic terms started at the base of the temperature gauge, and these would be considered the weakest. In fact, they're not even trademarks. These are common everyday names for goods and services. These type of terms are not registrable, all right? And some great examples of a generic term would be the wording milk. When milk is used for dairy-based beverage or alternative dairy-based beverages, okay? So like those oat milks and almond milks, etc. too. If you are selling a dairy-based beverage or some sort of substitute, and you want to use the wording milk as your trademark to identify that beverage, understand that a consumer, when they see that wording milk on a carton for this type of beverage, they're not going to have any idea where this product comes from because milk is not a source identifier. And that's why we consider it generic and not registrable with us. Okay, let's move on. So let's get some examples of descriptive marks. Descriptive trademarks are difficult to register and difficult to protect. These are marks that directly describe a feature about goods and services, and they're not registrable on the principal register, except with a showing of acquired distinctiveness under Section 2F of the Trademark Act. That's a long way of saying that you may be able to register a descriptive term if you can provide enough evidence that shows that your consumers still recognize this mark as being a source identifier because over time, because of your terrific marketing, maybe that mark has acquired enough distinctiveness in the marketplace so that it can stand out as a source identifier. All right. Here is a good example of a descriptive trademark that acquired distinctiveness over time. Scoop. Um, Actually, this particular mark was refused registration, okay, because it was considered descriptive. Um, Maybe over time it might acquire distinctiveness. I don't know that for a fact here, but I do know that this mark was refused. This was a TTAB, a Trademark Trial and Appeal Board matter, and they found that the wording scoop, when it was used to identify ice cream, was highly descriptive. They gave us a quote. They said that we find that scoop has little, if any, source identifying capacity as a mark for those goods, for the goods of ice cream. Indeed, they said they looked at the applicant's own use to confirm that the wording scoop is the most apt descriptor for measuring a serving size of ice cream. Okay. And so that is not, they did not consider that to be descriptive. I mean, they did not consider it to be a a source identifying trademark because everybody in the ice cream industry uses a scoop typically to determine the size of one specific unit of ice cream, okay, for a consumer, right? So that's coming straight from a TTAB matter. Suggestive trademarks. What about this? Suggestive trademarks are marks that require a customer to use their imagination somewhat to determine the nature of the goods and services. These marks suggest about something, maybe the quality or something of the goods and services. They're registrable. And an example could be Coppertone for suntan lotion or Netflix for streaming services. There's a couple of steps you have to take before you can get to the conclusion of what the type of goods and services are when you see the marks. So you might see Netflix and think Netflix. Okay, so these are movies and they're streaming on the internet. So Flix is another example, so synonym for movies, and so Netflix. Okay, couple of steps to sort of get to the type of product it is. We consider those suggestive. These are pretty strong. We're moving into the strongest types of marks, and these type of strong marks are marks that are protectable, okay, under the Trademark Act. What's a fanciful mark? This is another strong mark. These are marks that are invented, no meaning at all in any language. They are registrable. And you think of these as sort of coined terms, made up terms. Xerox for photocopiers, Pepsi for soft drinks, Kleenex for facial tissues. Okay. Before you file your mark with us, your application for your mark with our office, you want to go through this analysis because you want to have an understanding of where your mark falls in the spectrum because you want to avoid a refusal based on your mark being merely descriptive. Okay. How do you avoid that? You want to stick with the strongest marks, the fancifuls, the suggestives, okay, and the arbitrary. Arbitrary trademarks are those marks that are actual words, but they're not typically associated with the goods or services that are identified in your application or your registration. For example, Apple for computers. This is registrable, Okay, Apple is definitely in the dictionary, but it's not commonly associated with computers or software or retail store services selling those things. And so it's a pretty strong mark, considered arbitrary. All right, let's do a knowledge check to make sure that I've clearly explained the principles. In this case, we've got two different examples here. Which one of these do you think is registrable? This is not based on that likelihood of confusion analysis, but we're going to do the merely descriptive analysis here. Looking at the spectrum, where does this word bicycle lie? Now, understand that you can't make a determination about whether a mark is descriptive or not unless you know what type of goods or services are offered underneath it. So once I understand with this first example that bicycles are being sold under this wording bicycle, is that registrable? Mm, okay. What about bicycle if it's being applied to playing cards? Is that registrable? In this instance, bicycle for playing cards is registrable. In that example, bicycle is not descriptive of playing cards in any way, right? In fact, it is arbitrary. Okay. It's a term in the dictionary, but it's not commonly associated with playing cards. And so that's a strong mark. It's registrable uh, if you're just doing the analysis of whether it is merely descriptive. It's not descriptive. But here, bicycle for bicycles, well, that's generic. Bicycle in this instance is not even a trademark, and so it's not registrable. Great. Let's keep going. Filing and registration. Okay, so we're moving towards the end of the deck, and I'm so proud that you guys are still here with me. Thank you so much. Filing and registration. When you think about it, these are the broad strokes that every application flows through. 4 registration steps. So I like to add a fifth one because I'm hoping that before you even start this process, you're going to conduct a search using our trademark search system. So that's really the first thing you should do. Okay, conduct that preliminary search, and you're going to do it often up until the point of when you're ready to file, because people are filing applications 24/7. Okay, so you might conduct your search a week before you file, then again 3 days before you file, and then maybe right before you file, just to be sure that nobody has filed a new application that might be problematic when it comes to comparison with yours. All right. Here, after you've done your search, you're going to file. You're going to submit your application using our online system. It's called Trademark Center, and all over our website are some terrific training tools to help you understand how to navigate through this new system. It's very intuitive. We are super proud of how the interface looks and the feel of it, so hopefully you won't find any problems with it. So you're going to file through the Trademark Center. And then when your application is filed, an examining attorney is going to randomly pull it through our computer system, and then they're going to begin their examination. The examination primarily includes looking through the application, conducting a search of our own to determine whether your mark is confusingly similar with anyone else's or if there's a likelihood of confusion. Okay. And then the attorney is going to be going through a checklist of sorts to be sure that no other refusals come up. If your application moves through with no problems, no issues, then your mark will then be published in the official gazette. It will sit there for 30 days. If no one objects, it will move on to registration unless, okay, unless you actually filed your mark based on an intent to use. Now, when you file your application, you can file your application based on the fact that you're using your trademark to identify specific goods and services in commerce, or you can file based on intending to do so. If you file based on intending to do so, you have to still provide us with use, and you would do that after publication, okay? You would get a statement of use would be required, all right? So once you move through that process, your mark registers. You can't have a federally registered mark unless you're using your mark in commerce and you have provided us with evidence to establish that. Once your mark then is approved for registration, you'll get a certificate via email, that same email that's included in your application. Everything we do is conducted online through your email, okay? So we don't do any mail correspondence anymore. Electronic filing is mandatory, okay, except in very rare circumstances, okay? I did just say that we don't do any mailings, but there are some rare circumstances where some mailings might happen, but typically everything is done electronically. We have a mobile-friendly guided interface, the Trademark Center that I mentioned a moment ago. The drafts are automatically saved, which is a great thing. The application costs will be shown on the screen, so you're not going to be surprised when you get to the end. And you're going to be given prompts to complete information so that you don't omit any information, and so that there are no additional fees that will be required or added. All right. What are the filing fees? We didn't talk about the money. Okay. We want to make sure that we get this information in, because this is sometimes where scammers can sometimes sort of slip into this process. There is one base application fee for applications under Trademark Act Section 1. That's the most common type of application that most applicants file. If you provide a complete application and you only select listings of goods and services from our ID manual, okay, we have an ID manual, then you're going to be charged this base fee. All right, that base fee is $350 per class. But I also want to let you know that there are some other fees that might come up, additional fees. The additional fees would be $100 per class that will be added if you don't provide all the information needed in the application. And the application is going to say this information is required. There's going to be a red asterisk next to everything that's required. Okay. So there's an insufficient information fee. There's also a free form text ID. If you decide not to use the ID manual, which has pre-approved wording in it for every good and service, okay, that you might want to list in an application. But if you decide not to use that ID manual, you can use our free form text ID. And we charge to use for that privilege of drafting your own $200 per class, okay? Why do we do that? Because it requires our examining attorneys to conduct additional research and review, which sort of slows down the application review process. So we're charging a fee, hopefully discouraging you from this, and maybe trying to encourage you to use the ID manual. But in any event, we are happy to review whatever wording you provide. This additional fee will apply. Also, if you're using this free form ID and you're writing your own, if you go over 1,000 characters, you're going to be charged another fee, $200 per affected class. So that means that if you go over 1,000 characters for one class, like class 25, where your t-shirts are found, then that $200 would apply per the affected class, okay? And we'll talk about classifications in just a minute, how that comes about. What else do you have to do? A couple of things. We know that when it comes to trademark rights, they will last forever, right? But you are responsible for enforcing your own trademark rights. How do you do that? You can use your registration certificate as proof to support a cease and desist letter. You can use your registration as proof when you get ready to sue an infringing user in federal court, state court, okay? What are some other things you're required to do? As a trademark owner, you must file these registration documents after your mark registers. These are like these renewal documents. These are documents that say that, yes, I'm still using my mark, and that's what you want us to provide to us. Your trademark will last forever, provided you do this. So that means that if your mark registers on one date, you know that if you count 5 years into the future, between that 5th year and that 6th year, you have to file a declaration of use. That's a Section 8. And then between the 9th and 10th year after your mark registers, here's your mark registers, 9 years, between 9 and 10, you're going to file your renewal and your declaration of use, okay? You can check our website for the current fees. They are changing. I think they just changed, so you want to make sure you check in there to see what's the rate right now. But you're going to be charged those rates every between the 5th and 6th year, and then between the 9th and 10th year, and every 10 years after that, you're going to be charged these additional fees. Okay, and every time that those fees are going to be applied, there will be a requirement for you to provide proof of use. And that means some examples of how you're using your marks. It'll be like a declaration and a proof of use, okay? And you can find more information about that in the slide deck at that link that's provided there. Knowledge check. Are you guaranteed registration of your trademark? What do you think? Is it a guarantee? No, not many things are, right? You're not guaranteed. Every application has to be examined before it's registered. We know that our rules and our statutes change. Laws change all the time, and that's why every application is reviewed on its face. Okay. Sometimes there are procedural reasons to refuse, sometimes there's substantive reasons to refuse, and those rules change. If your trademark registers, do you have to do anything to keep your registration alive? Absolutely. You've got to maintain your mark. You're going to have to file those renewal documents and those declaration of use documents. These are Section 8 documents and Section 8 and 9 documents that have to be provided. These are the maintenance documents for your registration. And we've got an entire website dedicated to that and those fees. All right, we're at the end, almost at the end here. I want to just go through quickly how to find help. We've got lots of resources. So we know that scams is a problem with a lot of government agencies, and we are not immune. If you want more information, check out this web link here, uspto.gov/trademarks/protect. You want to be aware that folks are spoofing our entire website. Make sure that you're looking for the .gov at any websites that you are interacting with, because we are a government agency. So our our domain ends with .gov. All right. Another thing you want to be aware of is that once you file your application with us, because all of your information that you submit is publicly viewable by anyone, that means that your mailing address is going to be viewable unless you provide us with a PO box or such. It's going to be viewable. Your email is going to be viewable. Now, if you provide us with, let me take a moment and clarify this. If you provide us with a PO box, you're going to actually also have to provide your real mailing address, but that will be shielded. But in any event, whatever address that's going to be viewable to the public is going to be something that a scammer may want to use to contact you. So if when they do contact you, please bear in mind that our fees, as I say, start at $350. No one can obtain a federal registration for you for $99, for $50, $49, okay? Not going to happen. Our fees start at $350. Other thing you want to bear in mind is that if you have any questions about correspondence that you've received, you want to know, did it come from us exactly? I'm going to give you in just a moment a 1-800 number you can call so you can ask a real person, hey, did this come from you? And they're going to show you how you can check our database and be able to see into your file and to see all the correspondence that we issued and all the correspondence that you submitted or your attorney submitted. And you'll be able to see and compare what you received from us, from a third-party scammer, and what you might have received from us. That's how you can tell if what's legitimate or not. Make sure you check out our website, uspto.gov. If you're interested in learning through our videos, please do so at uspto.gov/TM videos. Also, if you're looking for a nice PDF booklet that talks about trademark registration from soup to nuts, go right here to our registration toolkit. I'm hovering here for a minute in case you want to snag that QR code. But if you don't, you can simply type in uspto.gov/trademark basics toolkit. Another thing to bear in mind is that if you're interested in 8 modules where you can see folks from my team, the Trademarks Customer Outreach Office, you can participate in the Trademark Basics Bootcamp. It's free. We'll walk you all the way through the trademark application and registration process, from searching to filing and beyond. We host this presentation once a quarter. It's 8 weeks, typically on a Tuesday from 2 to 3:30. And guess what? At the end of each presentation, there's a live Q&A where you can ask questions to trademark experts. So join us. The next one starts the first week in April 2025. And here again, additional resources. IP identifier, if you're trying to determine if you have a trademark, patent, or a copyright, go right here, ipidentifier.uspto.gov. And free services, please take this link down, uspto.gov/free services. That's where you'll find out about our law school clinic programs, where you could find a student attorney to assist you with searching your mark and drafting your trademark application, filing response documents. They will do that work for free, supervised by an attorney in good standing with a bar at some state in the United States, okay? And they will be able to provide that support. These are law school clinics and they're listed there. Plus, we have a virtual assistant, little comes up at the bottom of the page. Here's a fun fact. Put in your serial number or your registration number into that virtual assistant, and you'll be taken straight to your file where you can find out everything that's in your case file. If you're looking for like what did your attorney file for you, or what did you submit, or what did we submit to you? Okay. Also, here's that 1-800 number. If you need help, you've come at a point where you feel like you need some support. You've got a couple of good questions, and maybe you don't have an examining attorney assigned to you yet to ask. You can call the Trademark Assistance Center. This is our customer service arm, 1-800-786-9199. They're open from 8:30 in the morning to 6 p.m. Eastern time, and they will answer. This is a live person, not a robot. Also, you can sign up to receive trademark alerts so that you can find out everything that's happening on our calendar, all of our upcoming events, and any new notices from our office, changes in fees or changes in rules, etc. What don't we do? We don't provide legal advice. That's for your attorney. We don't enforce legal rights. That's for other agencies. And we don't recommend specific private attorneys. If you're looking for an attorney, start with the bar association in your state, okay? Or perhaps the American Bar Association. Okay, Sheila, we are ending here 60 minutes later, okay? But we might have a time for a few questions if you have some for us.
We actually have had one question drop in. I mean, I think you covered a lot of information. You covered it well. So I know we are at time too, but let's go ahead and see if we can get this one answered.
Okay.
The question is, can we file ourselves? Meaning we don't need an attorney to file on our behalf.
Absolutely. And we know that that's something that folks want to do, and that's why you're here listening to this presentation and others. Yes, you can. We do advise you, though, is to take your time and to review some of the information on our database and our website, because we are talking about legal rules and legal regulations, and sometimes they're a little complicated. So, absolutely, you can do it. We hope that you might participate in other webinars like this, maybe the Trademark Basics Bootcamp, because I think that the most complicated part about this is the searching. Searching is an art, and many times people might decide to hire someone to help with the search, and maybe they're going to draft the application themselves. And then sometimes responding to an office action can be confusing and a bit daunting. That means that you filed an application and there was some reason why the office thought that a refusal should have been issued. And now you're going to get a letter from a lawyer citing cases, rules, and applying the facts. Don't be intimidated. Many times you can read right on through it and see some suggestions from the examining attorney, right, to help you get through it. But you might want to hire your own lawyer at that point to help you navigate. It's completely up to you. If you decide the only people who are required to hire a U.S. lawyer would be folks who are domiciled, meaning they're primarily residing outside of the country, or their primary business takes place outside of the country. Their address, primary business address where they're conducting business, is outside of the United States. Those folks are required to have a U.S. licensed attorney. Everybody else who has that domicile in the United States can file an application themselves.
And, you know, we have one more question drop in, so let's go ahead and see if we can get an answer, and then we'll probably need to wrap up.
Sure.
But it's just for clarification. I have a business logo. I think the question is, do they need to trademark it or copyright it?
Well, I don't know per se because I haven't seen it and I'm not able to sort of give you that type of detail. But what I can say is let's think about what the purpose of each. If you want to use that logo to identify goods or services that you are offering in commerce, meaning in the marketplace for other consumers to access. That's trademark. If you want them to see your branding, your word mark or a logo, and you want them to say, I know where this product comes from because of this logo there, that's a trademark. If you're trying to protect the artwork of this design and you want to protect it from other people copying it or other people using it, and taking sort of putting their name in association with it, okay? Copyright protection. Copyright means that you've got artwork, okay? You created it as the originator, and you want to have the right to make those copies, you're protected because it's like it attaches when you put art in a tangible medium. Okay, that's when that protection sort of starts for copyright. Two different uses, two different purposes. If you're looking for help for copyright, go to our sister agency, the Copyright Office, the U.S. Copyright Office. It's at the Library of Congress, right, in Washington, D.C. But they have their own website with their own training modules and their own information that can help you with that process.
Okay. I'm going to ask one more question, and I think we should wrap up unless you have a little more time, Marisa, you can let me know. But it was can you please repeat how we can access help from student attorneys?
Absolutely. So if you're on our website, and let me see if I can pull that up for you. Okay, here we are on our website. If I wanted to just put in here law school, if I could spell school, clinics. Okay. Law school clinic pops right up at the top. Okay. And it's a law school clinic certification program. And if I click into the first drop down, it says get help from a law school clinic. Okay, participating law schools, look how many we have. They're all over the United States. And what's interesting about each one is that they will say, like here, American University, this one's located in DC, but it says the area that the geographic area where they support is DC, Maryland, Virginia only. But other places like Arizona State, their law school, they support all of the United States. So you don't have to necessarily be tied to working with a law school in your area. You can actually use some of these schools are all over the place, okay? And you can simply contact them and you can meet whatever their requirements are. I think it might be income based, but I'm not certain. You can contact them directly and they will put you on a list. Hopefully it'll be a short list and you'll be able to get a student to assign to you.
Okay. If you have time, do you have time
Oh,
for
yes,
one
of course,
question?
I do.
Okay, let's
Yes.
do this one. What is the ideal timeline of when to apply for a trademark? If I don't have branding, fonts, logos decided yet, and have not started doing business yet, should I not apply yet?
Well, you got to think of it this way. Folks out here have no creativity, right? They're constantly looking for things to snatch up. So if you are using this wording in some kind of way on social media or you've been talking to your friends about it, be careful because people like to sort of race and start to use something before you. And then, of course, their rights would attach before yours. Here's something you might consider. I mentioned earlier, we have this thing called standard character marks. So even if you don't know the font, even if you don't know what color you want, if you know the words, okay, you could apply for protection based on an intent to use your mark in commerce. So that means that you might not even know, like I say, the font, the color, but you got to know the goods and services some sort of way because you have to be able to list those goods and services in your application. If you can sort of nail down the goods and or services that you want to use, then you can certainly file your application today based on an intent to do so, an intent to use your mark. So you would just simply put in the wording, you would list your goods and services, go through the rest of the application and submit it. By the time that the application is reviewed in a couple of months or so, based on our pendency, you will have an opportunity after it's reviewed to submit an extension saying, you know what, I'm not quite ready. I'm not quite ready to go to market yet. I'm not quite ready to use my mark. And you could file up to 6 extensions, which is 3 years. So you can be hovering around for 3 years, but you sort of are just in a holding pattern until you provide us with the information that's needed to register, provided it has no other issues. And that information would be like your use in commerce information. That would be your date of first use, your date of first use in commerce, your examples, your specimens, evidence of use. So you could start right now if you wanted to.
Great. Okay, I think we have pretty much covered everything. Marisa, I want to thank you so much. Such a good webinar, so much good information. And I want to thank everyone who joined us today and remind you that you will receive an email with a link to the recording and to the slides. I hope to get that out by tomorrow. If you would like to sign up for upcoming webinars or access recorded webinars, please visit virginiasbdc.org/training. These resources are designed to be used in collaboration with your local SBDC advisors. You can sign up for a free and confidential session by emailing help@virginiasbdc.org or via our website. And we hope to see you at our next session. Thanks, Marisa, and thanks, everyone.
Thank
Take care.
you. Bye.
Bye.